My name is Richard Uslan. I'm an experienced criminal and municipal court defense attorney in Somerville, New Jersey, and I've been defending people like you for over 30 years. You're watching this video because you have a drug-related matter in Clinton. And in a previous video, I explained how an experienced defense attorney can challenge the evidence against you using issues of search and seizure as well as chain of custody. Now I'm going to use my educational background in the chemical and physical sciences to explain how an experienced attorney can challenge the scientific evidence against you. Excuse me. That evidence is going to come in one of a few forms. The first is the actual illegal substance that was claimed to have been recovered from you is going to be tested at the state police laboratory. We're entitled not just to obtain the complete records of that chemical analysis, but to require that the prosecution bring that chemist to court to come to testify and give us the opportunity to cross-examine. I know the various testing procedures that chemist is going to employ, including mass spectroscopy. I know how to read those chemists' notes and interpret them, so I know what questions to ask of that chemist to undermine their testimony that they performed these tests in a proper way that led to their conclusion that these were illegal drugs. Another way of challenging medical scientific evidence against you in drug-related matters has to do with blood or urine specimens that were allegedly obtained from you. Now, in the case of a blood specimen, that's going to be taken from a phlebotomist in a hospital setting. The blood has to be taken in a medically acceptable manner. If it's not, the blood test results are inadmissible in evidence. Oftentimes, the phlebotomist, the person who draws the blood, utilizes a blood kit that the police give to him or her. I get that blood kit because it contains instructions in it. In my experience, oftentimes those instructions are not followed. And just as we can require the prosecution to bring the chemist to court to testify, we can also bring that phlebotomist to come to testify as well. Those are not easy chores for the prosecutor to do, and their failure to present them at our demand will result in that evidence not being used against you. Now, that blood can also be tested not by a laboratory, state police laboratory, but also in a hospital setting. That will result usually in the blood being tested in serum form rather than whole blood. That can affect the conclusions that are reached by that chemist to our advantage. Now, in the case of a urine specimen obtained from you, the urine specimen, by definition, is waste. And the products that are in the urine are waste. You will not find active ingredients that affect someone's ability to conduct their affairs or drive in urine. They are what are called non-active metabolites. We can hire our own expert witnesses to assist us in drawing conclusions to help you in that defense. And because of my science background, I know how to conduct a direct and cross-examination of these scientific experts. An experienced attorney is going to do all of this. I've been doing it for over 30 years. I look forward to helping you and defending you in this case.